Uh, Today's session, when I was reading about the compilation made by the Academy, I realized two important things. Firstly, and which all of you know, the 49 notification and the Gangtok Rent Act and Eviction Act of 56 are very, very precise, and there is not much scope for, elaborate interpretation. But if you read the judgments of the High Court over a period of time, I find the judgments very nuanced. They have gone into the details of every word that is there, the effect thereof, and I think the law has already been laid down. For us now it is just to follow what has already been laid down and render judgment. Two things, however, I still haven't got an answer, and I wish all of you address this issue. In two judgments of this court, of the High Court, we have expressed concern about the area in which the Gangtok Rent Control and Eviction Act shall operate. But in spite of that, we continue to render our judgments on that. There is no definite answer in any of the judgments. If you are aware of it, please share it with us. And the common perception which we have had is that as far as Gangtok is concerned, we will be governed by the Gangtok Rent Control and Eviction Act of 56. And for the rest of the state, it is the 49 notification. If you look at historically, 49 came much before 56. So 49 was not a notification meant for the rest of the state 7 except Gangtok. 49 notification was for the entire state. It governed till the 56 notification act came in, and when the 56 act came in, the Gangtok Bazaar was secluded from the rest. So, and that you will find in another judgment of the High Court. That was for a period when I think when Justice Bhattacharjee, late Justice Bhattacharjee was there. I think because of the lesser number of matters that were pending before the High Court, they went into and examined in great detail the effect of each of these provisions. And actually, if you see the notification of 49, everything revolves around the provision of what you call that rule or whatever, two of the foreign aspect, which I thought you should all be able to address. The second aspect is on the question of, I think, eviction laws under the Transfer of Property Act 1882. This was something which I had not given much attention. I did some reading, so I would like to hear from you all before I express myself on that. But let us, also while in the course of these discussions, also discuss the various problems and issues that arise in your courts, respective courts, while these matters are on. Like in many cases, I have seen that the plaintiff actually doesn't talk about either the 49 notification or the Gangtok Rent Control. It seeks eviction. Sometimes I see issues are not framed as per these two notifications, but this act and the notification is binding, isn't it? So then how do we proceed further is something which you will also have to address yourself on this aspect, because without a proper issue being framed, you may not get the right answer, you know. And that takes us to the basic of the CPC, and I think we need to dwell a little bit on that as well. In few of the judgments, there is expression of the meaning of the word landlord and the meaning of the word tenant. And there is a little bit of difference between the 49 notification and the 56 Act. In one, the word landlord has been defined as the owner. In the other, it hasn't been. In Tika Khawas's case, Justice Dayal, late Justice Dayal, he has expressed an opinion, which we have followed, that therefore, in that case, the landlord need not prove that he is actually the owner. If he proves that he is the landlord, that is good enough, you know. But a thought which came to my mind is, we are talking about the state of Sikkim. Why this difference between the rest of the state of Sikkim and Gangtok? I don't think there is any need for this difference. So then how do we work out a solution for this is something which I think we need to also discuss. With these opening remarks, I think we can start. Let's make it interactive and let's take it on from there. Is the district judge there available? Then you put her so down that we can't see her. So why don't you just lift it up? Can I have these things down there, please? Can I sit down?
Hello?
Yes, madam. Yes, madam, we can hear you. Please proceed.
My sincere apologies because we had a small glitch in our connection. Hello, Director Sir, can I proceed or?
Yes, madam, please kindly proceed.
All right. So I think from the schedule given to us today by His Lordship, everybody will be aware that the core issue that we will be discussing today is the evolution of eviction laws in our state. I have been given the session on the notification of 1949, which appears to be the first kind of laws that that involved rent control. However, prior to this, Sikkim did not have any laws on eviction and rent control. So in 1945, the House Rent Control Orders of Kolkata and Bengal were adopted by Sikkim to enable the Sikkim to guide courts of Sikkim in rent control. And this came about because at that time, if you will note, 1939-45, we had the Second World War that was going on. So because of the Great Depression and the World War, there was a huge scarcity of housing all over the globe. Globally, there was a huge scarcity of housing. So, Sikkim, to keep up with the needs of the times, adopted the House Rent Control Orders of Kolkata and Bengal in 1945. Thereafter, in 1949, this notification was brought out. And for the first time in Sikkim, the notification defined who is a tenant and who is a landlord. And it also laid down the criteria for eviction, which I think you will find still continues in our present tenancy laws, Gangtok Rent Control and Eviction Act of 1956, because most of the grounds remain the same. It said that eviction could be granted on 3 grounds: for personal occupation, or for thorough overhauling, then for failure of tenants to pay rent consecutively for 4 months, and of course for these 3 grounds. So basically this is the content of the notification. Now I was not aware that Ms. Bebika was attending, because I was told she is on leave, but if you would like to, Judge Soring, if you would like to elucidate further on this.
Yes, ma'am. Thank you.
I will give you the case laws that you could read out. However, there's one more thing I would like to point out in this notification. An interesting aspect of this notification was that at that time one could be penalized under this notification if you violated the notification. You are liable to be prosecuted. So that's, it's a very short notification and very to the point. So Ms. Bebika, if you would like to inform the participants about the 2 case laws that we have in this regard, which have referred to this notification. I think it will all be shared on the screen.
Hello.
It's
Yes, ma'am.
Ms.
Thank you,
Bebika
ma'am.
Pentipo.
Lordship, good morning. Before we even come to the judgment, Lordship, the
Kamala
first thing
Guru
that we were given was this notification. So the query in our heads was like, how did this notification prevail or came into existence? So we did a little bit of a research, Lordship. So at that point of time, we found out that eviction, this notification did not abruptly came into Sikkim. What had happened was, we will have to go a little back, travel back in time, where we can see that, in medieval times also, feudal system created a complex web of rights regarding the responsibilities and the lands. So at that point of time, it was resolved through local customs and agreements between the landowners and the tenants. Then we come to 19th century, where during the Industrial Revolution, a significant turning point was seen when people started flocking towards the city and in search of employment, and eviction law had to be adapted there, changing social and economic conditions. So on one notable example of evolving eviction law in the advent of tenancy law was in England in 1915, Lordship. The Rent and Mortgage Interest Restrictions Act introduced rent control prompted by housing shortages during World War I. Sikkim also had sanctioned the adoption, and Lordship, I just presented Lordship this copy. This was the one which ma'am was referring to. Sikkim also sanctioned the adoption of the house rent control orders in detail in notice number 9/200/8 dated 9th April 1945 during the World War II. So this was the first adoption, Lordship, in Sikkim. On 20th century, a new significant expansion of tenants' right and development of modern eviction laws came into picture. In fact, Lordship, in 1930s, the Great Depression led to widespread housing insecurities, which led US government to introduce Federal Housing Administration and establish federal regulation for the housing market, which introduced measures to protect tenants from unjust evictions. In 21st century, eviction laws continued evolving, balancing landlords' and tenants' rights and responsibilities, introducing and implementing requirement of valid reason to evict a tenant. I think, Lordship, this was after that, this was the one which challenged the housing scarcity all over the world, and Sikkim being one of it, and this notification, Lordship, has streamlined the rent control determination. So this is the first, I guess, one of a kind to make an impact in Sikkim. This was actually the one which streamlined the rent and eviction.
This is absolutely new to me. I've never seen this notification before. So thanks to you all. Have you, the senior ones, anybody seen this before? We have not even addressed it in any of our judgments. We have not put it in perspective, and it is not in the reading material. You need to add this, no? Because it will give a historical. This is a very important thing that you have placed. Please carry on.
So I think this was the one, Lordship, and after that, I think after that the Gangtok Rent Control Eviction Act 1956 followed. Thereafter, I think there were a lot of judgments, which is like regarding this, Lordship, we have 2 judgments. We refer to our
regarding this notification.
No, Lordship. This the one 49.
49.
Then after the judgment, and I'm sure my colleague is going to talk about the Gangtok Rent Control Eviction, 1956.
Zola? I think she's referring to you.
No, I think as per the seniority, learned principal district and session judge will first address, then followed by Madam Jwala.
Good morning, one Lord. With my Lord's permission. The Gangtok Rent Control and Eviction Act of 1956. I think this is, if you compare the eviction laws, our eviction laws with any other eviction laws of the other states, we would find that ours is one of the shortest and perhaps the most precise eviction laws. But at the same time, my personal opinion is that it should have been a little comprehensive, because there are many things which are missing out and which in the course of the trial, I think all the learned trial court judges would agree with me that we do face practical difficulties during the course of trial and also while writing the judgment. Now, if you see Section 4 of the Act of 1956, there are 3, I think, if I am not mistaken, 3 parameters, 3 conditions under which a tenant can be evicted. Now, vis-a-vis the 1949 Act, sorry, 1949 notification, if you see Section 5 of the Act of 1956, there is one more provision which says subletting, which is not there in 1949 Act. But the question would be whether subletting would also be a ground for ejectment of a tenant. Now, whether Section 4 and Section 5 has to be read in conjunction or whether it has to be read entirely independently, this is, I think, one question which all my friends would agree with me. And then there is Section 12 again at the end, which would say that if there is any addition or alteration of the building, then he or she is can be subjected to ejectment from the property. Now, when we see these 3 provisions, 4, 5 and 12, many of the lawyers would argue in the court that only Section 4 is the main crux of the Act of 1956. But at the same time, and they would say that Section 5 cannot be read with Section 4. Now the question would be, is that so? Should we read it together? Or should Section 5 not be a ground for ejectment at all? Or if not, then why is Section 12 right at the bottom? Is it the problem in drafting? Or was it done deliberately? I think these are questions which has to be answered as well. And I'm sure my Lord would also agree with me that this is the question that His Lordship posed during the introductory session. Number one is, what is the jurisdiction under which the Gangtok Rent Control Act 1956 can be applicable? Now there is no definite definition at all. I think if you go back in time, when Honorable Justice Gujral and Honorable Justice E.M. Bhattacharjee passed the first judgment, also there was no definite answer to what Gangtok would, or the jurisdiction of Gangtok would be under this act. And because the Gangtok Rent Control Act would say that it will depend on the notification of the government as to what the jurisdiction of Gangtok would constitute so far as this act is concerned. And from 1956 carrying perhaps till 24, at least I have not seen any notification from the government which defines the boundary of the act or Gangtok. Now if you see the case of Goparma, Honorable Justice Wangdi had penned the judgment. Now this I remember because I had to refer to this case in one of the judgments that when I was dealing, and the property happened to be somewhere in Tadong. And the question was whether, or it was not direct question but indirectly, that the Honorable High Court then said that Tadong will not come under the jurisdiction of Gangtok Rent Control Act. Now what would be applicable is that notification of 1949. So the confusion within all of us is, if Tadong is not Gangtok, then will Gangtok only be surrounding Gangtok per se? Or can it be extended further down towards Deorali and Tadong? Now since there is no definite notification and there is no definite answer, and perhaps if many of us like me, since I was not conscious, I was not aware of this judgment, I could only see there, and the Honorable His Lordship posed these questions to all of us also. We would perhaps say that Tadong is also Gangtok, following perhaps Gangtok Municipal Corporation's notification of the jurisdiction of the GMC. Now these are, I think, one question which it will always come in our mind. And the second question, if Lordship and my learned friends would also guide us, is whether Section 5 can also be read in conjunction with Section 4 of the Gangtok Rent Control Act, or should it be just for the purpose of penalizing? Because the Act also says that if the certain provisions of the Act are not followed, then that landlord or the tenant could be prosecuted. Now, should Section 5 be read only for the purpose of prosecuting, or should it also be one of the ground of ejectment? And these are the questions that has come to my mind, and since I do not have a definite answer, I would seek my Lord's indulgence and my friends'
What are the views of the
views.
Yes.
Lordship, just to continue on what our learned principal Discipline Session Judge has elaborated upon, apart from talking about the rights and duties of the landlord, the Act also talks about the duties of the tenant, in particular in Section 12, where no tenant shall make any additions or alterations to the building or damage the structure in any way, save in the course of ordinary wear and tear, without the approval in writing of the landlord, failing which the landlord shall have the right to evict such tenant. So I would say that actually Section 12 is also an addition to what is already there in Section 4. Section 4. And also I think it can be read along with section 5. Like section 12 will give not only the right to the landlord to add a fourth ground for eviction of the tenant, but it also gives an additional duty apart from section 5 to the tenant not to do these things, on ground of which he can be evicted. So like the rest, all of us are very well versed with the act, so I would not want to go on with that. But in continuation of what Karma sir has talked about regarding the jurisdiction, which was discussed in Jokiram, even I was very, I just like kind of in my research, it's always like we all left with a lot of questions actually, like sir.
That's important to have
yes,
questions.
Yes, Lordship. So I was just looking at the timeline of the judgment and also the the formation of the Gangtok Municipal Corporation. So it was, it came into the Gangtok Municipal Corporation Act is there in 1975. The judgment was passed in 1976. And then we also have a Gangtok Municipal Corporation Amendment Act of 1980. Now, Adarsh, can you go to the... So, I don't know what was the gap there, but had Jokiram been it's just an, so Lordship is just an opinion.
Of course.
Like, not a criticism, I'm not that thing, but it's
I
an
think
opinion.
The High Court should be open to criticism as well.
That had...
in discussions like that.
No,
Isn't it?
I would not want to do
No,
that,
no,
Lordship.
no.
But
Please,
had...
go ahead.
And this is like there in the website of the Gangtok Municipal Corporation. What is Gangtok? So, by 1975, Sikkim was already a state. So, if the old law had been interpreted along with this new
This
law,
came in when?
the Gangtok Municipal Corporation Act of 1975.
75.
So, the boundary, the GMC boundary has been subject to amendment on and off. One was in 1980. So, I feel like had the judgment been interpreted with the Act of 1956 along with the Gangtok Municipal Corporation Act of 1975.
But does it define the Gangtok Bazaar?
Not the bazaar. It's the GNC.
That's right.
Now the question is the Rent Control Act only with bazaar or would GMC, because it's a municipal corporation. A municipal corporation.
What is your answer?
Is an urban body, and it's an urban area. A municipal corporation is basically an urban area. Just like a Nagar Panchayat would be an urban, a semi-urban area in a panchayati kind of a rural setting. So my feeling is that had the old Act of 1956 been interpreted along with the 1975, probably the boundary of Gangtok Bazaar, which already in our service questioning, why is Tadong not Gangtok? Probably it would have been defined area by now. So Gangtok Bazaar, as understood in 1956, which is particularly in my opinion just MG Mart as of now, but Gangtok we understand now is like much bigger. So my opinion is that had these two been interpreted.
So what now? If as a judge, if you were to interpret this section, this provision,
probably the definition of what is Gangtok.
You will have an expansive understanding of the words used in the Act. That is, Gangtok Bazaar would then extend right up to Tadung and perhaps Ranipul then. Why not Ranipul?
Why not Ranipul, Lordship? I'm just going to Gangtok Municipal Corporation Act only, Lordship.
No, so the Gangtok Municipal Act extends Gangtok from where to where?
So it is there in the website.
What is that? Just give me a thing.
From Tashibi Point to, from the east, others till about Ajitalla. It's very expansive, Lordship. Tickling Jhoda, like it's very particular. And there is a map also. There is a map of Gangtok Municipal Corporation also, Lordship.
But do we agree with this view that the Gangtok Bazaar, as contemplated in the 56 Act, would, should be covered by the Gangtok Municipal Act, which defines an area called Gangtok? What are the views of the judges?
Lordship, now I think Even more confusing it will be now because of the renaming of the districts. Gangtok district will now cover the entire. So now, can we say Singtam Bazaar is not Gangtok Bazaar? That is again getting more and more confusing, Roshan, now.
Okay.
I'm just going by Gangtok Municipal Corporation because a municipal
I understood what you're
body
saying.
is a constitutional body, Roshan, and there are certain criteria for a particular area to be declared a municipal corporation. So if you look at Gangtok of 1956 and we look at Gangtok of 1975 and of 2024, Roshan, I think interpreting these three in the current circumstances, population-wise, everything in terms of necessity, urban
This is
necessity.
the first question which we need to answer. Sorry, I'll just is what the Gangtok Rent Control and Eviction Act of 56 saying. 1(3). If you read 1(3).
That's what I was about to point out. 1(3).
Okay, just point it out.
It shall extend to all buildings and constructions situated within the area of Gangtok Bazaar, which may be fixed from time by the Sikkim Darbar.
From time to time. that's
Yes.
it.
So I think this is what we'll have to see. What the government is fixing as Gangtok Bazaar.
Ah.
So I would see that, Lordship.
So Lordship, here again the same question, like
Ah.
the GMC has come, let's see, GMC has now been notified to cover the entire Gangtok municipality, right Lordship? So by virtue of that, it may extend to the GMC, areas falling within the GMC. But now with the new, again the renaming of the districts, that also is part of what the government has done. So now, should
We
it
will
also...
be here to resolve problems.
Lordship, I think an amendment of the 1956 Act defining bazaar as equivalent to municipality would
Oh, that's a
actually-
legislative change, which is not in our domain. So what do you do?
Lordship, interpretation can be done. Probably.
Would that be right?
I
Would that be
think so.
right?
Lordship, it's for the government to issue a notification under this act to include the area as municipality.
The first question, I think it's important as judges to ask the right question. So when we read the provision 1(3), it says very clearly, it shall extend to all buildings and construction situated within the area of Gangtok Bazaar. It's a declaration. So I would believe that the Gangtok Bazaar was well defined in 56 when this act came in.
Yes, yes. Lordship, yes.
Correct?
Yes, this
Oh.
Gangtok Bazaar, Lordship, at the time of enacting 1956 law, I think impliedly already in existence. So,
Correct.
yeah, so
So the
Lordship,
question to you is,
Lordship.
where is this notification, where is this rule, where is this particular, circular which defines the Gangtok Bazaar? A little bit of research we need to do ourselves.
Lordship, this my director, deputy director, may I think I request to.
Lordship, I can't remember the exact notification number, but once I had discussion with Jyoti madam in one particular case, so wherein through her guidance only I had come to know that there is a particular notification where it is
Okay.
defined where what are the urban areas in Gangtok. Like for example, Shari is a rural area, but Tadum would
Can you-
definitely
can you
come under
ask
urban area,
your
but I cannot
office?
remember the notification as of now.
Can you ask your office to get the Sikkim old codes? Just get it. So now let's look at it, how Sikkim has evolved, how have we grown. And it's very important for us to understand our history. Our history will explain these things. Part of it I know because many of these bazaar were set up by my ancestors. So therefore it is there in my head. If you look at how we have, evolved over a period of time, you will notice that the then monarchy was looking at the development of Sikkim in different aspects. As I see it, a lot of settlement was also encouraged to generate revenue. Therefore, we had settlers.
Therefore, the parchas were made, the khatyans were prepared. At the same time, there was a consciousness, and also, of course, guided by the council. We need to improve our business. Economic activities needs to be generated. So bazaars were set up. Now if you look at again back, take for example, we have this, the Bisitang resort, which most of you must have visited, isn't it? That was part of what do you call, what is that word? Help me in this now. Grant given by the Chogyal to the family, and it was a huge estate, right? Little below that Bisitang is this little bazaar. What is it called? Mangalbari Bazaar. Mangalbari Bazaar, if you look at it historically, was part of that estate which was granted to the Bisitang family. Right? Now, to encourage economic activities for ease of, a lot of activities. At that time, people needed to eat. It was not as if everybody had their own thing. So, ration, pani, whatever. So a bazaar was set up in that particular estate. And much later, perhaps in 80s, if I know, that area was declared as the bazaar. And there is some kind of a dispute that is going on between the family and the government with regard to how can my estate be taken by a thing and declared a bazaar and suddenly it becomes public property without giving me any money. That perhaps was an issue which has been raised. But bazaars were set up by the then government. So the Gangtok Bazaar came in, the Rangpo Bazaar came in, the Pakyong Bazaar came in, the Rongli Bazaar came in, the Renok Bazaar came in, and slowly it kept on going further and further. If I am not mistaken, these areas were declared as bazaars by notification issued by the government then. It was so because some of the notification you will find that what is the word used in that? Business people, basically. It doesn't use the word business people. What is the other word? Huh? No. Not money. Plainsmen, I think that could be a word, plainsmen, and something else has been used in the notification, I'm foggy. But that has been used to allow the business community to settle down in the bazaar area. That's why you see in Gangtok Bazaar, permission is being granted to purchase property in spite of the law that no outsider can buy land. Isn't it? Those are the laws which are there. But in Gangtok Bazaar, suddenly it is like an island which has been created. Now these islands were created of various towns which was declared as bazaar. And that was what the bazaar that was meant in the 56th Act. The bazaars were in existence when the 56th Act came in. Activities were happening, right? But that makes me a little more curious, and I want to do what you are doing. Pose the question to you. What was the bazaar then in Gangtok? So the Gangtok Bazaar, somebody mentioned MG Marg, right? When did MG Marg come in? The word MG Marg, when did it come in? Then it was not MG Marg, right? So the Gangtok Bazaar was divided into two sections, the Purano Bazaar and the Naya Bazaar. At the time of 56 Act, correct me if I am wrong, when the 56 Act came in, only the Purano Bazaar was in existence. The Naya Bazaar was not there. Now I have not seen any notification which includes the Naya Bazaar into the Purano Bazaar. Of course, now it is called MG Marg or whatever, but there is no notification. I have not seen it. And this is again something which we need to do some research to catalogue all these things. But this is what Bazaar was meant in the 56 notification. Now comes the Municipal Act. What was the purpose for which the Municipal Act was enacted?
One main intent was to control municipal sewage and all, because there are provisions dealing with how you cannot wear fakes, horses have to be somewhere else, you cannot wash clothes. So all of these things are there, but even in the Act, there is no definition of what is the Act in 1975. There is no definition of what Gangtok Municipal Corporation would be.
No, the question to you is this. When the 56 Act says that the Act will apply to the Gangtok Bazaar, should we be looking at Gangtok Bazaar as the two words on its own? I'm talking about statutory interpretation. Or you can go to Gangtok under the Municipality Act. Is that a possibility? Interpretation laws, interpretation of statutes. What does the interpretation of statute say?
I think we should stick to what is literally.
That is what the law teaches us. Statutory interpretation is, it is very clear, it says Gangtok Bazaar. It doesn't say Gangtok Municipal Area. So therefore, how do we now supplant Gangtok Municipal Area to mean what 56 contemplated? It may be very difficult and far-fetched to do that, because again, Bazaar had a particular connotation. Why was it necessary to enact the Gangtok Rent Control and Eviction Act in 56, saying that this act will apply to Gangtok Bazaar very, very specifically? Go back to the 49 notification. Look at it. How does it, where does it, is there a restrictive? See the first paragraph, it's an opening paragraph. Under powers conferred in Rule 2 of Notification 1366 dated 47, the following rules have been framed to regulate letting and subletting of premises, controlling rents thereof, and unreasonable eviction of tenants as the scarcity of housing accommodation still exists in Sikkim. See, this was applicable to the whole of Sikkim, right? But somehow the authorities at that time felt that this may not suffice, and they brought in the act to restrict the act to the Gangtok Bazaar. Otherwise, it is the 49 notification which is prevailing over the whole of Sikkim. So what was this special need in 56, and what was that special thing in the 56 Act which was not there in 49? That's the question I want to pose to you. What was the need? I mean, law comes because of the need, isn't it? So what was the need to bring in the 56 Act? And what was special in the 56 Act which was not covered in the previous Act? As we read section 2 and 4 and 12, much of the provisions are almost the same. Isn't it?
I think.
Lasik,
Yes.
Lordship.
Who's speaking? Okay. Yes.
yes, Lasik, this section 12, Lasik, I think if we read section 12, that is just elaboration of ground 2 of section 4.
Correct. Yes.
And section 5, 6 and 7 start with the negative sentence meaning thereby. This act is cautioning the tenants
Not to do it.
not to do this because there is a penal provision,
Ah.
section 13, Lordship. Yes, for my limited knowledge, Lordship.
No, but that I understood. But the question which we are asking is, we are still confused about where this law will apply. Because it says Gangtok Bazaar. So that's the question.
So the question would now be, apart from Bazaar, we have to go by the Eviction 1956 Act. Bazaar, and then the rest of GMC. Who is going to, and what is which authority is going to control the rent and eviction of GMC area? Apart from Bazaar, which we understand from that.
These are questions which the legislature will have to. These are questions which you need to ask when you vote the people to power and tell them to do certain things. We keep voting and people to power without even giving them anything to do. So they will enjoy what they have, the 5 years and go away. We need to make them do things which we have not. We can't, as judiciary, we can't. These are, limited areas. Our job is to interpret the law and to ensure that people get justice, to the extent that is possible. We can't go beyond that.
One thing is the municipal corporation, that of GMC, one of the primary function of GMC is to give trade licenses. Now, are there, differentiating between the bazaar area and the GMC as well? So all these things are also there.
No. I think you're going to a state of confusion. We don't need to go there and confuse ourselves so much. Eviction law is for basically, it says it is Gangtok rent control. So first is rent control, we have to control rent, and eviction act, right? So this is the primary purpose of the act. The municipality laws are for some other purposes. So let's not confuse the two. These are two defined areas which it works on. You were saying something?
I think, Lordship, the question that Lordship posed regarding what is the difference or what Gangtok rent control has and the notification does not is perhaps by 1956 commercial activities had started growing a lot.
Correct.
Especially in and around bazaar areas. And if you see the difference of words is constructions and buildings, they've started rapidly developing in bazaar areas, which we don't find it in 1949 Act. And I think in order to control, because the rent in these areas would be much higher than the other parts of the state. So in order to control that particular rent, because it was, otherwise it would be haphazard. Somebody would be charging 1 lakh.
Absolutely correct.
1 lakh for a small premises. Others would be paying pittance, 500 rupees for the same. So in order to have a uniformity, and also, I think if you see 1956 Act as well as the notification, this is more in favor of the tenants, so that they don't get ejected unreasonably without.
The 56 Act is more in favor of the tenant compared to the 49.
Yes.
And why do you say that?
No. I mean, both of these acts
more bent towards
the tenant, and more because of the fact that the housing accommodation is not much, and perhaps Gangtok town or Gangtok bazaar was not as big as it is by then, and the buildings and construction that were coming up there may not have been sufficient to hold, to give accommodation to one and all, especially the business community, and in order to promote some kind of commercial activities, so that there is some economic development. Perhaps I think this Act of 1956 had to be brought in.
That perhaps is the closest answer we can get in the historical perspective, right?
Lordship, to add on to what our Principal District Judge Sir was saying, I think same is evident by Section 6 and 7 also, which says that no landlord or tenant shall keep either the whole or any part of the business premises facing the bazaar side as a godown. So to ensure that the commercial spaces are not being wasted on that aspect.
So there was, as you pointed out, there was a need at that time
to now have a more elaborate act. Because a lot of commercial, as pointed out by the district judge, a lot of commercial activities were happening in Gangtok. Gangtok was by then the capital of Sikkim. Therefore, obviously the concentration would be in Gangtok. There's a lot of influx into Gangtok at that time, right? And by those notifications, the business community was allowed to purchase property. Before that, the revenue order number 1, the other circulars issued by the government from time to time restricted their commercial activity only to these areas. They could not purchase land anywhere outside. Land acquisition was still not thought of as a mode to give land to the people who did not. Now it is rampantly used. You see. So at that time, this perhaps was the reason why they had to bring in the act, and therefore, the words used 1-3, Gangtok Bazaar, according to my understanding, must be restricted to the Gangtok Bazaar and can't be beyond that. Nobody argues this in the courts though. And we can't innovate our arguments.
So I think now it's like Gangtok Bazaar. We have a Venn diagram of what is Gangtok already there. Inside the port would be Gangtok Bazaar and outside would be the GS. So Gangtok Bazaar would be actually a part of Gangtok Municipal Corporation.
Yes, of course. For the purpose of the Municipal Act, yes, you're right. But not for the purpose of Eviction Act. The Eviction Act is working in a completely different domain. You can't be snatching an idea from one legislation and bringing it to another legislation. How do you do that? Unless it is in the same field.
Is Gangtok Bazaar, is there a particular jurisdictional definition of Gangtok Bazaar?
That's the question I'm asking you all. You're posing the question to me. Yes, according to me, and if somebody can, who's coming up, please look at this. So, full notification in which they will say Gangtok, Pakyong, Rampo, Rongli, whatever, are declared as bazaar areas.
Lordship, just an information, because about all these old laws that we may have to refer time and again, and many of us don't have access to a hard copy. I think it was under Lordship's guidance and chairmanship that we have also included all these old laws, scanned it, and we have put it up in the High Court's website.
But how do we use it? And why are we not using it is a question we need to ask ourselves now.
Just an information to...
You're absolutely right. It's all there.
I think it would be faster if we refer to...
That's right. Yes, my search got us now.
Yes.
Why don't you do a search on this and say Gangtok Bazaar? Just
Bazaar.
I don't know whether that is double AR.
Just interrupt.
Yes, yes, please. You're so far away.
I'm in agreement with you in that this Gangtok Rent Control Eviction Act of 56 is very specific that it pertains only to Gangtok Bazaar area, because in the preamble itself it specifically says it is for accommodation in Gangtok Bazaar.
Correct, correct.
If it was to beyond Gangtok Bazaar, then we would have, it would have opened, the notification act would have opened with something like which would have repealed or referred to the 1949 notification, which was applicable generally to the entire state of Sikkim.
Correct. Correct. Absolutely. It has to be Gangtok
Only
Bazaar.
for Gangtok Bazaar, as your Lordship has pointed out, not for the municipal area.
No,
And
municipal
extended
area was
to
not
the
even thought of.
area the legislation have to, because it provides from time to time they can extend the area. So unless that is specified, we will have to go by what is specifically mentioned in this 1956 Act.
And that is where the difficulty is. The notifications which I am aware of are those which, look at that. People residing within the limit of Gangtok Bazaar will apply directly to the chief court and not to the Gangtok Qazis for stamp they require. Now this is of 1916. So the bazaar was defined much before that as well. You see? Let's look for other one. This is a bazaar committee. So there was in fact a department called the bazaar committee. So it was not as if in Sikkim people didn't know what was the Gangtok bazaar. No, but this is not the one I am looking for. This is that all. Just write bazaar instead of Gangtok. Next. This is, which year is this? Go. The following bazaars are under the direct control of the Darbar at present, namely Gangtok, Deorali, Tadung, Singtam, Rangpo, Pakyong. See? Now, this is under the municipal rules of which municipal rules?
Go down other more bottom of this. Is that there? 1924. So you already had a thing.
1924. Now, this seems to be, see, this is how interesting it becomes, So, even this in 1924, much before the 49 Eviction Act came, bazaars were already there. This is go back to the same place, where it talks about the bazaars. We take a clue from here, right? The following bazaars are under the direct control of Darbar presently. Gangtok, and there is Deorali Bazaar. Right? So, Justice Wongki was not wrong.
No, that I'm not saying that.
No. I'm saying, no, it's not wrong. You didn't say it, I'm saying it. In fact, he was right, isn't it?
Yes.
Because
Yes.
Gangtok,
Correct, Marshal, correct.
Deorali, Tadung,
Correct.
Singtam, Rangpo, Pakyong, Rongli, and Sore.
Correct.
But besides this, I have also seen another couple of. So all this, I think you need to directors have.
Yes.
You sabai nikalera ni tapaile एउटा compilation बनाएर you must circulate among all the judicial officers, and maybe we have another session where we can come to a conclusion as to what is the Gangtok Bazaar. So we need to be very clear because we are deciding these cases every day.
Lordship, by using a logic of this particular notification, I think it is absolutely correct that Gangtok Bazaar constituted only that bazaar area, because even Deorali had a bazaar of its own.
That's right.
Tadung had a bazaar of its own,
Oh.
and so on and so forth. So Gangtok must have had a bazaar of their own.
Correct.
But we need to at least know as to what is that jurisdiction. 1956, yes, by using a logic, it could have been Purano Bazaar, not even Naya Bazaar or Lal Bazaar. But thereafter, did it extend to Naya Bazaar, New Market, or at least go down till the Lal Bazaar, or should we only confine to that particular area, Purano Bazaar, which is now the MG mark? So that may be one question which will come up.
We need to answer.
Yes, because
The problem is right now, no lawyer has questioned this.
Yes.
So therefore we are happily oblivious of it. We just ignore it and write our judgments.
Yes.
And perhaps write also, when this issue crops up, we will render our thought on that.
Because we have dealt, yes, Lordship, we have dealt with cases where Naya Bazaar is also included
That's right.
under the Gangtok
That's right.
Control Act.
That takes me back to my research earlier. There is definitely a notification which defines
Gangtok Bazaar as the Naya Bazaar, the Purano Bazaar. Purano Bazaar is Tharo line lekin udhar. The rest is all Naya Bazaar. So that area again is not covered by those notifications. Even these notifications, it did not exist, right? The Naya Bazaar came in much afterwards.
I think that's the reason why it's known as New Market even now.
That's right, that's right. And beyond my house it was jungle and nothing else. We were actually stationed in the edge of the jungle. And beyond that was like chaos. If those notifications, another thought, if those notifications, we talks about Gangtok Bazaar as Gangtok Bazaar without giving a defined area as the Municipal Act would do, you know, north of this, south of this, till the Jora, above this, if that is not there in any of these notification, then would our interpretation be right to say Gangtok Bazaar is Gangtok Bazaar? Wherever the bazaar is, if it is now expanding, Gangtok Bazaar is extending towards the national highway and going down, and that is also the bazaar. No, if there is the notification could be two ways. One notification would be Gangtok Bazaar means area south from this, north from here, and east from here, and west. It gives a very defined area of 500 square kilometers or something like that. Then we know what is this. But all these notifications, if it said Gangtok Bazaar only and did not define the area, then would we be right as judges to interpret this word Gangtok Bazaar not in the context of what it was then, but what, because we are applying the law even now. So can't we have an expansive interpretation of Gangtok Bazaar? It doesn't define what is Gangtok Bazaar.
There is a reasoning, no? This has been, this was enforced and it came out.
But these are all hypothetical questions unless we come to a conclusion by looking at those notifications. I think the academy must take this exercise.
Plus, just our learning deputy director talk with law department. They will, I think, assure us to supply the relevant notification. Then we'll please before Lassi for sharing to other law department.
The law department,
Lassi, खोजेर दिन्छु
we have the PDF. Passing the buck sometimes is damaging. It doesn't work.
I don't know, Lottie, whether this will help, but there is one municipal rule for a bazaar in Sikkim.
We saw that 24. Go.
24, the following bazaars are directly under.
That's right. We just saw it just now. Here. Not this. Not this one. The earlier one, which he took out. We've already seen that, and we were arguing and are making a hypothesis based on these structural changes that has been brought about by these new knowledge. Also presupposes, if you see the wording out here, presupposes the existence of bazaar and a defined bazaar much prior to this act coming in, isn't it? So we need to date it back even beyond that.
So in this Lordship with this act, if you just look at the schedule, they have specified the area, bazaar area as Gangtok and Deorali.
The Sikkim Bazaar Committee Act of 69.
Yes, just
declared any area to be a bazaar area for the purpose of this act, and until otherwise there is a number of state will remain as specified. No, why can't we use this act?
but it says only for the purpose of this act.
That's right. But what is the purpose of this act?
So if you scroll down, just scroll down, there is a schedule of the bazaar area.
Correct.
But it's not specified here also, it's only written Gangtok.
So basically the act is, if you see, the act is to constitute a committee for proper governance, isn't it? Yes, duties and function of the bazaar committee. So the bazaar, as would be understood in this act, would be the same bazaar which the Eviction Act would talk about.
Just come down to the schedule,
Isn't it?
little below.
Can we have this act?
Yes,
Can I
yes.
hold it in my hand? Can you get this out? To define the bazaar, right, and constitute committees to govern that. Now, this is in 1969. Much prior to that, in 56, right, the 56 Act talked about Gangtok Bazaar. I don't see much of a difference between what they used as Gangtok Bazaar, not about the area, but I'm saying the use of the word Gangtok Bazaar in the 56 Act would be similar to the one which is contemplated here. It is the bazaar. And Gangtok Bazaar has in 1969 been redefined to include Deorali for the purpose of this act, right?
So Deorali will be under the...
Now if you go back to our Eviction Act, if you look at it very closely, it shall extend to all buildings and construction situated within the area of Gangtok Bazaar, right? It doesn't say Gangtok Bazaar as defined under this act. It doesn't say that. Then it says which may be fixed from time to time by the Sikkim Darbar. The 69 is also by the Sikkim Darbar. I'm just putting my thoughts. I'm not laying down the law. Okay?
Lordship, with all due respect, I
don't
like
agree.
to differ.
Okay. It's just hold
Lordship,
your
because-
thoughts there. Just hold your thoughts there. Hold your thoughts there. So now it goes right up to Deorali, according to. But what is the difference then? I mean, you have a negative thought. So let's keep your negative thought right now. What do you think? Anybody agrees with me?
I agree.
Oh, two of you agree.
But they've chosen to not include Pradhan Bazaar in the 1969.
Sorry, which bazaar?
Pradhan.
It poses a lot of questions. Yes. Okay, but this and the rest of you.
What about in between Deorali to
त्यो क्वेशन त 25 का हामी त 69 मा 69 सम्म त पुग्नु पहिला तपाई त 24 मा पुग्नु भयो नि त 69 सम्म त पुग्नु यार सुवर्ण म्याडमले त किन छोडपन गर्दिनु हामीलाई yes now give us your thought.
Lordship, my thought is, this is only to define the committee, Lordship, the bazaar committee. This is only for the purpose of the committee. So the committee for Gangtok would include Deorali Bazaar as well as Singtam Bazaar and Rampu Bazaar. But the bazaar as per se has not been defined, Lordship. The bazaar is still segregated. It still remains, Gangtok Bazaar is Gangtok Bazaar only. Deorali Bazaar still remains. But the schedule of the bazaar area in accordance with section 2L of Sikkim Bazaar Committee. So if we go up, the purpose of the, in the beginning.
No, that is when you look at the words Gangtok including Deorali. Remove including Deorali. My question to you is, Bazaar Committee is formed for the purpose of management of the bazaar. So the bazaar contemplated by the Committee Act and the Eviction Act, would it be different?
Yes, Lordship, because
How would it be different?
this is only for the purpose of forming the committee, Lordship. This committee
I
has
understood. The question is, forming the committee for what?
to oversee the activity
If I
of the
were to
bazaar.
say, if the Act would say
that a committee to be formed to basically look at the grievances of the judicial officers, and another committee formed to look at the emoluments of the judicial officers. Would the judicial officers be different for these two things?
In that example, it would not be lordship, but here.
Then what is the difference here? Committee I understood, but it is to manage the bazaar.
Bazaar. So
So
the
what is the
second
difference between the bazaar contemplated by the Committee Act and the bazaar contemplated by the Eviction Act?
If you can see, the bazaar is defined here in this notification. If bazaar is defined here, sir,
No. Okay. Let's see.
bazaar.
Understood what you say. So no, the government of Sikkim, look at the constitution of bazaar here. So it is the same thing which the Eviction Act is also contemplating, isn't it? The government has the power to define bazaar, but would it be right to think like what Madam Suvarna is saying, that bazaar for the purposes of the Committee Act would be different vis-a-vis the bazaar under the Eviction Act, and then there must be a bazaar mentioned in the Municipal Act, and there could be the bazaar mentioned in some act to control and regulate the lal market. So would it be then different? Then you will have different bazaar areas for different purposes of for different acts. Would that be right?
Maybe we need a Gangtok Bazaar reorganization.
Ms. Walla needs to be in the legislative domain. Yeah, she'll work wonders there. Mr. Pradhan, what are your thoughts on that? Would it be different? Committee I understood, it's a different purpose. But committee to manage the bazaar. So why would the bazaar be different under the Committee Act than the bazaar under the Eviction Act? Gangtok Bazaar is Gangtok Bazaar.
I still am of the opinion that the committee will extend to Gangtok Bazaar, Deorali Bazaar, and one single committee will pay. Lordship.
You're not answering the question. You are getting restricted in your thought with the words used, Gangtok including Deorali. Remove that thought completely. Right? Now question is, when the Committee Act refers to Gangtok Bazaar, would it be different than the Gangtok Bazaar contemplated under the Eviction Act because of two things? One, the Gangtok Eviction Act does not define Gangtok Bazaar but leaves it to the government to notify that. If you would have been right if the Act defined what is Gangtok Bazaar. So the Act did not think of restricting the definition of Gangtok Bazaar to a limit and limiting it to an area. It left it to the wisdom of the legislature to expand the Gangtok Bazaar as and when it deemed necessary. That is what I understood from the Act. Isn't it? So it may not be a fixed area at all. And according to me, it should not be. Otherwise, you will go back to the Purana Bazaar, and therefore I will not be able to evict any tenant. I strongly protest that.
In the new Gangtok Municipal Corporation Act,
Ah.
the old one was never. I mean, Lordship, when the new laws after 1975 were made in Sikkim, there should be some kind of a bridge with the old law, because you cannot repeal or remove or kind of thing of the old laws. But
Yeah, so, what the legislature did not do, the judiciary has stepped in and by judicial interpretation held certain things. Like, we had something called the debt law. The debt law was of 1800 and something, isn't it? If you see our, that bundle of old laws that we have, perhaps that's the first notification which is there. If I am not mistaken, the Sikkim High Court in AR 1999, Sikkim page 1, it was something to do with the rent control and what is the act? Debt recovery and whatever act, right? While looking at that, the Sikkim High Court held that the old law, the debt law, because of the coming into force of these acts, is now gone. The Sikkim debt law. So wherever this happens, it is open to judicial interpretation to step in, There are a number of these issues that keep coming up.
just not. Sikkim is a bazaar. Right now, it is a normal. Now, there is a neglection there. Jordan,
Why are you stuck with
Lordship,
municipal areas?
because bazaar in the old context, because municipal areas have got the same kind of definition. It has to have a certain amount of population. It has to have a certain amount of.
Yes, correct.
All of these are there.
But bazaar, it may not be a bazaar area, no? Please understand, the Municipal Corporation Act defines Gangtok to be a municipal area, which is not a bazaar. Bazaar is bazaar. Bazaar भनेको त सौदा गर्ने ठाउँ भयो त, सब्जी गर्ने ठाउँ भयो त, हैन? लुगा किन्ने ठाउँ भयो त, हैन? बजार भनेको त्यो नि त. It is not municipal will include washrooms also. Gangtok bazaar may not include that.
I feel that chance was missed in while enacting the Gangtok Municipal Corporation Act in 1975 and also amendment in 1980. Like I said, it's like you have a Venn diagram. Bazaar is one side, and you have the jails.
Correct, right.
It should have been put here. Now this.
Yes, to that extent, yes. But we are now focusing on an issue with regard to the eviction laws. So let's restrain ourselves to eviction laws.
If we go by one of the purpose of the Gangtok Control Act, also for fixation of rent.
Correct.
The question is who is fixing rent to bazaar and who is fixing the rent for the rest of the.
That the Act itself says.
But do we have an
The Act itself says. So the procedure that has been followed, which I don't know, many of you may not know, I was introduced into this procedure by Mr. Tej Thapa. Under the Act, and one of you just read that. 6, if you read 6. Either the whole or any part of the business premises facing the bazaar street as to go down as long as parties may be available to take up the premises on payment of the standard rent. No landlord or tenant shall keep either the whole or any part of the business premises facing the bazaar street closed down for a period exceeding 6 months. If he does so, the Sikkim Darbar will have the right to take possession of the premises and let it out to anyone else whom it thinks proper, provided that the landlord will be first given the opportunity to let out such premises himself on being so directed by the Darbar. Now, these two provisions are being used in Sikkim in this way. I don't know how many of you are aware of this, but and there was a number of cases that happened. Bazaar premises facing the Bazaar street kept locked. So an application is filed under these two provisions. This is being done in the office of the UDST by a notification issued by the government. A senior officer of the government in the UDST department has been authorized to regulate this. So he acts as a quasi-judicial authority to implement these provisions. And there are a lot of these orders which have been passed by these authorities after extensive evidence gathering and rendering a judgment. Many of the cases. I don't know, are you aware of this? So it happens that way. So there is a notification issued by the government by which authority has been given to a person in the UDST at a very senior level. I remember Mr. Tej Thapa going and filing his petition there and getting his orders from there and going there and you discuss with me, I would assist him and help him and getting all kinds of, legal issues resolved, and then he would ultimately satisfy and get this order under 7. If he does so, Sikkim Darbar shall have the right to take possession of the premises and let it out to anyone else whom it thinks proper. So if you don't, as a tenant, if you do not use the premises, then you didn't have a right to be there. It should be given to somebody who would use it effectively. And the Darbar had the power to throw that person out and get somebody else out there. So use this channel, the landlord using this channel, the landlord would say throw this out and give it out. So you would get a higher rent as well. So there would be a fixation of rent. You would take out a cranky tenant who you don't like, because the tenant wouldn't know many of these laws. These two are something which is not there in many of the judgments. So this is how this has been working in Sikkim. But that question which you posed, 5, no tenant shall sublet the premises either in whole or in part to a third party without the consent of the landlord. Should it be read with 4? Was the question Mr. Karma posed. What are your thoughts on that?
I feel like even section 5 and 12 are also grounds for eviction under 4, because there are similar grounds in other acts also. In Delhi, rent control, West Bengal.
So because if there is a similar ground in Delhi, then it should be the same thing here.
Bare reading also.
How does the bare reading?
It says no tenant shall make any additions or alterations. And
no, I'm talking about 5. Please restrict your answer to 5. 12 is very clear, 5 is not. 12 says it leads to eviction.
Subletting is also a big issue, which which goes to the root of a contract between two persons. Subletting is, I think, a big.
Okay. Give thoughts.
So I feel subletting
is a big what? Issue.
A big change to the initial contract between the parties of.
What is a contract? What is a contract? Tell me. It is an agreement
between
two
persons.
It is in writing or oral.
Yes.
Right? If the agreement contemplates that under the contract that you should be thrown out, then it's different. What if it does not contemplate that it is thrown out? You should be thrown out.
That's why they have used the word without the consent of the landlord out here.
That's right. But what is the consequence of this action?
So consequence also
4,
will be.
look at it.
Yes, sir.
Okay, just change your thoughts now. 4 and 12. If you read 4 and 12. 4 talks about the consequence of the action. Correct? It will lead to eviction. Read 12. 12 also says it will lead to eviction. Right? So why doesn't 5 say so? I'm putting the question on the reverse now. That's your interpretation. But Mr. Karna posed the question, should it be also read with 4 and 5 together, and shouldn't it be a ground for eviction? And that is what the learned judge is saying, that it should be, because Delhi has a legislation which says if you sublet, you should throw out. No, there is nothing to laugh about. That is his thought.
I think, when we give our premises for rent, there is an implied agreement that it is not for subletting. So even if it is for subletting, here it is mentioned without the consent of the landlord.
See, you're going into different domains now. You go into multiple areas. And if you put yourself in a situation where you try to understand one situation with another law, then you may get confused. The question which we are asking ourselves is the rent legislation, not the Contract Act. When you pose a question with regard to the Contract Act, we will answer that. But today, the Rent Act is before us.
I think somebody has to do a field work about whether there is a Gangtok Bazaar committee existing till date. Is there a committee or not? And then ask them, what is Bazaar according to you?
Lordship, this could be,
I don't think so there is any Bazaar.
this may just be a bad drafting also, because 4 is there giving a ground for eviction, then straight away in 12 they are giving a ground for eviction, so it could be bad drafting also.
Yes, to that extent bad drafting, but you can't add words because of bad drafting. The legislature did not do so, so I am supplementing it. Which interpretation
Then
law allows you to do that?
Out here, Transfer of Property Act may come in.
Answer my question. Under what law does the judiciary have the power to supplement and add words into the statute? We are interpreters of the law.
Under a general lease also, I think
These,
under Transfer of Property Act, I think
why are you going to transfer? Why are you getting so confused with multiple acts? Why are we going into multiple acts? Transfer of Property Act is for a particular area of governance. This is eviction law. So why are we getting into lease, that is again Transfer of Property Act, contract, that is the Contract Act? Why are you going to these different areas? What is the confusion in the head?
As per me, the Transfer of Property Act is a general act. So out there, if a tenant does sublet, it's a ground for taking back possession.
Under the Transfer of Property Act?
Yes,
Very good, excellent. Decide a case according to the Transfer of Property Act, but you can't bring in the Eviction Act and take out interpretation of Transfer of Property Act and put it in Section 5. How do you do that? If there is a ground for eviction under the Transfer of Property Act, right, then please exercise that power and authorize the eviction under the Transfer of Property Act. But how do you say 5 will have to now bring in Transfer of Property Act? Under what understanding of the law is this? No, I just want to understand your thoughts. Where do you get this interpretation from? Why are you shaking your head? Tell me, when you were so confident, because I have been forceful, and please understand this, I've been a lawyer, so I'll always be very, very forceful. You know, even if I'm wrong, I will make sure that you will say I am right. This is the art I've learned over 3 decades. It will not go away. So I want your thoughts. Where are you getting this interpretation?
My original thought was because these are also grounds for eviction in other rent control acts also. So
Just hold your thought there. Let us say, now I'll take the situation a little further. The Delhi Rent Control Act, okay, authorizes the eviction of a tenant on a ground which is not available under the Gangtok Rent Control Act. Would I be saying that although, in my judgment, would I be right in saying, although the Gangtok Rent Control Act contemplates eviction only on these 4 grounds, however, the Delhi Act contemplates the 5th ground, and therefore I evict you on the 5th ground? Answer this question. That answers your issue also.
But if I may just
Yes.
put in a word or two.
Yes, please. Yes, please.
Lordship, the intention of the Darbar in this notification, I think, is very clear when they made separate sections 4 and 5.
Correct.
In 4, you still have the 3 grounds for eviction as mentioned in the 49 notification. In 56, they introduced rule
12.
section 5, which says subletting, but does consciously leaves out the word court here. And if a tenant violates this, then I think all that you could do was turn to 13, where for contravening or violation of this, you could be, made to pay of 1,000.
That's right. That's right.
They intended to have the courts involved.
I would agree with that
They intended
interpretation.
to have eviction as a ground, subletting as a ground for eviction. They would have included it as they did in the Cultivators Protection
Absolutely.
Act.
That's
if I'm
right.
not wrong, I think it was specifically mentioned that subletting would lead to eviction.
Correct. Absolutely right. Absolutely right. I think that would be the correct interpretation. What do you feel, Mr. Karma? Don't you think that would be the right thing? Otherwise, 5 would have very clearly said that it would lead to eviction.
Yeah.
I do not agree with the very vigorous argument.
Lordship, but that would also create another problem.
What?
The subtenancy would still exist. The subtenant can again further bring subtenants, and nothing can be done about it.
Mr. Jabian, while you wear that attire and sit on that chair, please be mindful that you are a judge and not a legislature. You can't take the burden of the entire state's laws and the lackings therein and give your interpretation to suit the legislature for all the inactions. We are to interpret the law as it is. The first rule of interpretation is that read the statute as it is. If there is, the language is absolutely clear, don't raise doubt about it, because there is a presumption that the legislature knew exactly what they were writing. So this first, your view which you expressed, bad legislation, okay, that may not be right. Judicial discipline permits us a little bit of leverage on it. When it is absolutely pronounced, when there is no semblance of sanity, then you may go to that domain. Otherwise, interpretation of statutes tells us that please understand that the law is that the parliament and the state legislature knew exactly what they were doing. They knew their intention, they used the words to implement that intention. So you don't have this thing in your mind that because of bad drafting, now I will do something about it. You're wearing the wrong coat and sitting in the wrong chair. For that you will have to go to the state legislature and to the parliament for that. You can't do it in the chair that you hold. Right? Read it as it is. How can you create a doubt there? It doesn't say so. Then you are adding the words shall evict in 5. Where do you add shall evict there? When 4 says very clearly 3 grounds available, evict. 12 says addition and alteration, evict. Why did the legislature think it fit not to say evict in 4? Or are you saying the bad legislation, the people who drafted it did not know English? How can we come out with these thoughts? That's not for us.
I found this one solution further help us in our identify what is a bazaar area. The Land Revenue Department of Position number 1205 talks about what is a Bhaskar and like this determination of cases relating to land be to be notified as follows. So all Bastiwala, primary holders, secondary holders, Ukiadas, Adiyar, cars, then agricultural land, all of that. And there is one particular thing that says that bazaar areas are excluded from the operation of this section. So agricultural land, whatever areas, is not an agricultural land, it's probably a bazaar area. We do by this.
No. That would be very thick, no? Agricultural land is now defined under 2013 Act. So if you go there, then your bazaar will, I don't know, start in Gangtok and end somewhere, I don't know where. Even Kopivari will be bazaar there. Please have your TA, they've given us so much. Who's there? I don't understand.
Notification of 1955 that defines important bazaars and less important bazaars. Just sharing it.
Why don't you compile all of these together and let us do that? I think this is a very serious thing. Compile all these things which defines bazaar. Okay? Put it in chronological order. Right? And circulate it among all of us. And I request the Academy to have another session where we will discuss and take this further.
Lordship, if I may be permitted, then maybe we can call the legal remembrance also and slightly given the hint that Sikkim Gangtok Bazaar needs to be defined by virtue of a new notification.
Of course we can.
Today Lassivi is on leave, therefore.
Tell him we miss him in all these sessions. Because every time we hold a session, his need is felt more.
In fact, Lordship, every time we have a session, Lordship, I think
Lassif, let's we have a tea break for 15 minutes. Then we'll switch over to next section.
Yeah. Rupnarai, we discussed this many times regarding this, who is Rupnarai. He was a Sindhi man. He came in 1915 or 16 or 17 as the Judicial Secretary to the Maharaja. Soon he found himself as the Chief Judge of the Chief Court. And he was there till for donkey's years, 54, until the what do you call, the Diwan came in. So he used all his resources to get in the Indian laws. So all these notifications were again drawn from various sources and
I think this, this section 5 of the Act of 1956. So the literal interpretation is absolutely right, Shiva.
subletting.
Yes,
Fine.
subletting.
Ah.
But no, this is not an opinion of a judge, but generally, once you read this act, person in Gangtok takes on rent a premises, and then if he takes sort of, let's say, 3 rooms, and then he sublets to 6 persons, then that 6 person will again sublet to another 16 persons,
And so on and so forth.
so on and so forth. Then I think what will happen to the right of this, the landlord?
Again, you're right.
Yes.
Does the legislature needs to contemplate on
I
that?
think there will be chaos.
Correct.
Once people come to know that this is not a ground for
Correct.
eviction, there will be chaos.
That's right. So this kind of problems, this is not the only problem we have in Gangtok and Sikkim. We have multiple problems, multifaceted problems, which needs to be resolved by the state. The legislature has to step in. In 2 judgments of the High Court, the High Court has given an opinion advising the state that these laws are inadequate, and therefore the state legislature must step in to undo this wrong. What was good then is not good now. Today we have more complex situations like you posed, and therefore it is upon the state legislature to do it. Where is the state? There in the two, it's part of the compilation as well, isn't it? Here,
I think municipality mostly came up in order to generate some revenue for the government, and not for trade license. Yes,
that's right.
and not for eviction and rent control. And I think Lordship, for this tenancy and sub-tenancy subletting, we could refer also to the judgment of Dr. Yogesh Verma. There is some mention about subletting there of the Hon'ble High Court.
We are looking at that in the last segment, is it?
Just for the general.
Okay, that will be fantastic. I wanted to pose to you, and I keep worrying about it, therefore I want to. When a matter is, argued before me, I find lawyers do not do the necessary homework, and therefore they don't give us what was our earlier opinion. And my worry has been constant from 2017. Am I writing an opinion which is contrary to opinion rendered earlier by a coordinate bench or by a division bench? So if there was an opinion rendered by a coordinate bench earlier and we ignored it, or it was not cited before us, so we gave a contrary opinion, what according to you would be the correct view of the High Court? No, there was an earlier view which said that this is the law. Yeah, this is the law. Section 4 interpretation is this, right? And then I rendered an opinion in 2017 which says the interpretation is that. Now, to you, if one lawyer like me comes to your court and gives both the opinions and says, here is the first view and here's the second view, now you decide, what are you going to do?
look at the strength of the bench.
The coordinate bench I'm
The
talking about.
coordinate bench, the earlier judgment would prevail.
Correct. Why are you all confused? I knew the answer would be there, but why are you not giving me the answer? I'm just looking at your faces. These are things which you have to keep in mind, when you are writing your judgments. These are things which may happen to you, and you should not be foxed in situations like this. For the fear of saying, no, but Justice Bhaskar is still in the bench, but that opinion, the judge is gone, so I might as well say Justice Bhaskar is right.
Actually, I was reading what's Mr. Daftari's some sort of an autobiography, not an autobiography, but some writings, and he would recollect an anecdote in the Supreme Court, in the Hon'ble Supreme Court, where the bench, one of the member was recently elevated from Bombay High Court, and he would be arguing on certain point of law where that particular honorable judge had given a different opinion in his judgment in Bombay High Court, and he had come on elevation to the Supreme Court. And while he was arguing, the honorable judge was saying something contrary to what his opinion was in that particular case in Bombay High Court. So Mr. Daftari reminded him, saying that if you think that, if Lordships think, not particular judge, but the bench thinks, that the opinion rendered by a single bench in Bombay High Court is inferior to what the bench in the Supreme Court would think, then you may take a call. So I think thereafter the bench in the Honorable Supreme Court also thought that particular opinion of that Honorable Judge in Bombay High Court was correct, and then stuck to the same opinion there.
So that reminds me of two incidents which I must talk to you about. I'm very fond, you must have heard about this several times, but for the younger ones. Many years ago, when I was practicing the Supreme Court under the senior, one matter came to us, and I was given charge of that matter. I read the brief, I read all the papers. My opinion is that they lost the case in the Calcutta High Court. My opinion was that we're not going to win this case, right? So there's no point fighting in SJA. So I gave my senior the opinion. My opinion was accepted by my senior and told to the client. The client, however, was adamant. He says, look, I need this premises, it was an eviction law, for at least 6 months. So SLP must be filed. So my senior called me promptly and said, file the SLP. He gave me no choice. So I had to create grounds. So I read and reread and read and burned the midnight oil. Then I told my senior, look, I have a point, but we need Mr. Falinariman. Let's go and brief him. So I went. So we managed to get an admission on the point, like you mentioned, that the single judge who gave an opinion against us in the eviction matter, we were the tenants, had rendered an opinion when he was in the Patna High Court. And he followed that opinion. He did not know that a division bench of the Calcutta High Court had given a contrary opinion. So, Mr. Falinariman, with that acumen, he went to the court, he just said this. I must point out, the learned single judge decided to follow his opinion of Patna High Court and ignored the division bench judgment, admit the stay. So we managed that. Thereafter, the matter came up for final hearing and I had an opportunity to brief Mr. Rohington Nariman, Justice Nariman. When I went to him, his first reaction was, Bhaskar, there is no case in this. Forget it, I am not aware. But I insisted that he must read, and I gave him a couple of judgments. The point which I had raised was, the eviction suit was filed by a partnership firm which was unregistered. Under 69(2) of the Partnership Act, there was a prohibition that an unregistered partnership firm cannot sue against the other if it is arising out of a contract. The suit was based on the contract, plain sense. It was a lease deed. So that was the point I had raised. After reading for a while, he said, okay, come back tomorrow at 5 o'clock. When I reached at 5 o'clock the next day, and this was his, greatness. He didn't have any juniors, nothing. In the brief which he had given to him, he had made, and he has this very, very tiny handwriting. On one side, he had written down judgments in our favor by different high courts, and the other judgments against us by different high courts. The moment I said, Bhaskar, read all this, and you have a case, huh? We'll argue it. So I was very happy. When the matter was heard in the Supreme Court, just an eviction matter, other side was Mr. A.M. Singhvi. It became so interesting that this was a regular hearing matter, so it would come up between Tuesday and Thursday. That 4 days, the courtroom is to be packed with senior advocates with their notepads, jotting down all the points that was being argued. It became so interesting. The judges were noting down, and I was, as a young lawyer, I was elated to think that because of my, hard work, all this excitement was happening in the courtroom. So, while my senior would be arguing, I would be looking back and enjoying all that was going on. After the arguments, judgment was reserved. A month later, the judgment came. We lost the case. And we lost the case, and this is what I want to point it out to you. That's the reason I'm telling you this story. The plaint was in 6 or 7 paragraphs. The entire interpretation of and if you see the plaint, it's art of drafting. It's really art of drafting. Nothing external, everything precise. It said what it wanted to say, it prayed for what it wanted. In para 2, it had said that because of these actions, there was a lease deed and all that, and because of these actions, I am entitled to the relief as per the covenants of the contract, that's the lease deed, and the law of the land. This was the language in about a 20 words paragraph. Series of arguments, as I said, hundreds of judgments cited. Ultimately, the opinion of the Supreme Court, Justice Majmudar's opinion, it said very clearly, there was a lease, by a flux of time that it came to an end. After that, he became the tenant, now was authorized under the covenant of the contract, had become tenant at sufferance because he was holding over. The law does not permit the landlord to physically take him out and throw it away. So he has to go to the court to secure his eviction. Although under the covenant he ought to have gone. By influx of time, it was all over. So the period after the end of the contract, where he becomes a tenant and sufferance, is governed by the Transfer of Property Act. Right? And under 111 and 108, he is entitled to eviction. And the cause of action comes from that words used in para 2. I am entitled to eviction under the contract and the law of the land. The 3-4 words and the law of the land did the trick for them. Because 69(2) restricts its applicability to contract. If you read 69(2), it is pertaining to contracts. So had the 4 words and the law of the land not been there, we would have won the case. But because these words were there, it took us to 111, 108 and 69(2) was thrown out of the window and we were asked to be evicted. But that was after 4 years. My client needed 6 months. We gave him 3.5 years more. So they were happy. And this is, I think it's a very interesting thing because it tells us a couple of things. It tells us that it is important for us to look at the pleadings very closely. A contract contemplates something which is beyond your rent act. Then how does it work? It's something which you need to think about. Who's going to start the 2 sessions?
Yeah, plus if you are London District and Session Justice,
Yes,
especially
Mr.
the one.
Yes.
Gangtok.
And good afternoon to all the judicial officers present here. With the permission of the Honorable Lordship,
Please go ahead.
this session is with respect to the discussion with respect to the eviction law under Transfer of Property Act 1882. The Transfer of Property Act 1882 governs the transfer of immovable property in India. Eviction law in India pertains to the transfer of property temporarily to the owner, from the owner to the tenant. With respect to the eviction law under Transfer of Property Act 1882, relevant section of the Transfer of Property Act are section 105 to section 117 of the Transfer of Property Act. Section 105 discuss about the definition of lease. Section 106 discuss about the duration of certain lease in absence of written contract or local uses.
106.
Yes, that's it. Section 107 discuss about the lease how made. And section 108 discuss about the rights and liabilities of lessor and lessee. Section 109 discuss about the rights of lessor transferee. Section 110 discuss about the exclusion of day on which terms commence, duration of lease for a year, operation of determine of lease. Section 111 discuss about the determination of lease. Section 112 discuss about the waiver of forfeiture. Section 113 discuss about the waiver of notice to quit. And section 114 discuss about the relief against the forfeiture for non-payment of rent. Section 114A discuss about the relief against forfeiture in certain other cases. Section 115 discuss about the effect of surrender and forfeiture under lease. Section 116 discuss about the effect of holding over, and section 117 discuss about the exemption of lease for agricultural purpose. With section 111 of the transfer of property, there is a judgment with respect to this section of our own Honorable High Court, 1985 SCC Online Sikkim 2, General Secretary Dharmachakra Center, Rumtek Monastery versus Denjung Cinema Limited. In this judgment, there is discussion with respect to the section 111 of the Transfer of Property Act. I think this will discuss by the Ranjita Madam in the next session. With respect to the section 105, 106, 107, 108, 111 and 114 are the relevant in the eviction law. All these sections are relevant in the Transfer of Property Act 1882 lawsuit, and with respect to the detail about this section, Subarna Madam will discuss about the relevant provision.
But I concentrate more on Sikkim. This is general. We are administrating the law in Sikkim. How does it work in Sikkim? So can we talk about that?
Good afternoon, Lordship. Good afternoon to all the officers present physically and virtually. With regard to Sikkim, Lordship, under the TP Act, Lordship, eviction of property can be done on the basis of section 108Q. On the determination of the lease, the lessee is bound to put the lessor into possession of the property, which Lordship was earlier talking about. Then we have section 111, Lordship, of the TP Act. So here again we have the conditions on which the lease can be determined. Then I was just thinking, Lordship, the question that Lordship had earlier posed, this is with regard to lease to the contrary. I think by virtue of the judgment of the Honorable Supreme Court in Madan Lal versus Bhai Anand Singh, the burden is actually on the lessee.
Which means?
The burden of proving a contract, lease to the contrary, is on the
Okay, but
lessee.
okay, that I understood. Yes.
With respect to applicability in Sikkim, Lordship, I think this is still a very grey area, because we have these two notifications in place for eviction, right, Lordship? In Gangtok, we have the for applicability of the law in Gangtok, we have the 1956 Act, and then for rest of the state, we have the 1949 Act, notification. So TP Act, I'm not very sure the applicability, since it has not been formally again enforced also in Sikkim.
What?
The TP Act. I mean,
Of course it has been
no, after the
it has been enforced.
The judgment.
I'm absolutely.
Enforced.
What?
Enforced, sir.
By notification, it has been enforced.
Yes.
Be clear about that.
Actually, TP Act, I haven't really dealt with too many cases, Lordship, and
No,
even eviction
that-
also.
That is why I pose this question. This topic is something which all of us need to dwell a little bit more. Remember the question I put, in many cases I have seen that the plain does not talk about the rent acts. The prayer is also very clear. Issues are not framed, right? But we are rendering our opinion as per the rent acts. Then I thought to myself, what about the Transfer of Property Act? Is it not applicable? It is applicable. So then, if 101 permits, then why can't it be tried on the basis of that, under the Transfer of Property Act?
Lordship, in most of the cases, lease deed as well as tenancy agreement, most of the council used to file in eviction suit, Lordship, and most of the lease deed are unregistered, Lordship.
So that's a different problem. But now I would urge you to take this compilation again. Let's look at the compilation and let us look at the first notification which is there, the 49 notification. Do we all have it? So it starts like this. Under powers conferred in para 2 of notification 1366 dated 47, the following rules have been framed to regulate letting and subletting of premises, controlling rents thereof, and reasonable eviction of tenant as the unreasonable eviction of a tenant as the scarcity of housing accommodation still exists in Sikkim. So what do we understand by this? That the legislature in 49, when they were making this notification, was very clear that there was scarcity. So there is no question on that. It is not to be determined by us whether the scarcity is there. They are saying there is scarcity and therefore making the law. Correct? Now, 2. Let's look at 2. And it starts with a restrictive note. The landlords cannot, CANNOT, eject the tenant so long as the scarcity of housing abundance lasts. In the first preamble, it declares there is scarcity. In para 2, it says that landlords cannot eject as long as the scarcity lasts. If the legislature was the one who pronounced that there was scarcity, who would be the right authority to pronounce that there is no scarcity? It would be the same legislature, the same authority. Do you think we have the capacity and the capability without that kind of empirical data to pronounce on that? So that is very clear. There is scarcity, and the restricted word is landlords cannot eject. Correct? Now let's go to the next one, the Gangtok rent control and eviction. Starts with a, look at 4. A landlord may not ordinarily eject any tenant. Full stop. There's a statement. That's the law declared. You shall not ordinarily eject any tenant. And when, however, it tells us you can't eject, but when, however, these conditions are there, you may evict it. It is not shall evict. For your information, the West Bengal law will be mandatory. If non-payment of rent, if I am not mistaken, right, it would lead to a mandatory ejectment. But our law in Sikkim, if you read, may eject. It is not mandatory, it is discretionary. Do you understand the differences between the two? So we can't just take from one and put it here. That's why I am focusing on you. Right? Now, as far as this is concerned, bringing back to that topic, whether the Transfer of Property Act is applicable or not, and whether you could evict under the Transfer of Property Act. That's the question, isn't it? We have seen these two Rent Act, which are both restrictive. It says landlord cannot evict as long as scarcity lasts. And the other one says ordinarily you shall not evict unless these conditions are fulfilled. Both there are set of conditions on which eviction can happen. Right? Now let us go back to the Transfer of Property Act. And which is that provision which you talked about? 108, 108, isn't it?
108 Q Losher.
Let us start, not go to Q, let us start with the very few words in beginning of 108. Can we read it? In the absence of a contract, you got that verse? In the absence of a contract or local usage to the contrary, the lessor and the lessee of immovable property as against one another respectively possesses rights and are subject to liabilities mentioned. So the question to you is, if there is a contract or local usage to the contrary, then what would happen? then that would apply. That will apply. That is very clear with this law, right? Then look at 106. Duration of certain lease in absence of written contract or local usage. This is the provision which in the rest of India is used to evict under this law, isn't it? Now it starts in the absence of a contract or local law or usage to the contrary. The question to you is, if there is a contract or a local law or usage to the contrary, then would this provision prevail? Because 106 contemplates giving a 15 days notice and evicting without any grounds. So in Sikkim context, Subarna, what do you think is the answer?
Lordship, in the
Answer.
with the two notification of the Act that is in existence, I think 108 we cannot directly apply, Lordship.
106 also.
106 also, definitely, agriculture.
In the absence of contract, local laws. These are
Yes,
should-
but that's a slightly different.
I think only when it comes to eviction, then the special acts will apply, otherwise Transfer of Property Act is still applicable.
Of course.
108 talks about
We're
rights
talking
and
about
liabilities.
eviction only. Today we are discussing eviction.
So when it
Nothing
comes to the eviction, then we'll have to follow the special act.
Correct. That is what the law says. I am not saying it. The law is saying it. Absolutely correct. It's not as if Transfer of Property Act is eradicated. No. But in Sikkim, because of the special law, the question to you was, would it be alright for us to exercise the power under 106 and evict? So let us say an eviction suit is filed saying that I have given a 15 days notice because 106 says, if you read now, in the absence of so and so, so that we go for, shall movable property, a lease of immovable property for agriculture or manufacturing purpose shall be deemed to be a lease from year to year, terminable on the part of either the lessor or the lessee by 6 months notice, and lease of immovable property for any other purpose. Let's go to the any other purpose shall be deemed to be a lease from month to month. Right? So there is a lease which has been granted for non-agricultural, Gangtok or a rent property. It's been given. Right? He now issues a notice under 106 and says, I'm giving you 15 days notice, please get out of my property. He does not cite any reasons why he wants anything. He gives the notice as 106 is required. The tenant does not comply with the notice. The landlord comes to your court and files a suit for eviction on the ground that I gave this 15 days notice as required under 106. He has not got out of my property, please evict him. How will you determine that suit? Was the question.
But 106 is only for agricultural or manufacturing
No, it is
purpose.
not. No, it is not. Go to the next point. See, if you go further down,
And immovable property, any other purpose.
any other property, right? So it covers both the areas. So it would be, let us say, Gangtok town property, right? Any other property is given, right? Now, a suit is filed in your court saying that I gave a notice under 106, 15 days time granted to him. It's been 40 days, he has not got out of my property. please evict him. How will you determine that suit?
Lordship will not be maintainable
It will not be maintainable because
because the eviction is under the Gangtok rent control. It should be under the Gangtok.
why?
Lordship, because it only says 106 says in the absence of a local law,
Right.
and also the Gangtok rent control act also says.
To the contrary, why are we not reading the word contrary? What is contrary to 106 vis-a-vis the rent acts? That's the question I'm posing to you. That we know it can't be done. But why?
106 talks about eviction without any grounds also. Whereas the Gangtok rent control talks about grounds.
Correct. But this issue is no longer res integra. Ms. Jyoti just pointed out a judgment in Dharma Chakra. If you read the judgment in Dharma Chakra, you will find that it refers to a constitutional bench judgment of 1979 Supreme Court. In 1979, the Supreme Court was facing with this situation where the Supreme Court itself had rendered conflicting opinions. One set of high courts followed one set of the precedent of one thought process of the Supreme Court. The other set of high courts followed the other set of precedent of the Supreme Court. So chaos in the country. Conflicting views from different high courts, law administered differently in different parts of the country. Faced with this situation, the matter came up from the Constitutional Bench. And the Constitutional Bench in that judgment of 1979 rendered an opinion that the notice contemplated, it said a couple of things. It looked at the most of the rent laws across the country and said most of these rent laws have restrictive and provisions which restrains the use of 106 by the words in the rent acts. Some specify that it will not apply and it should be done only as per the rent act. Some, by use of certain words, impliedly say so. But these are the kind of provisions which are there. However, the Supreme Court says that in such situation, when there is absolutely restraint, right, then 106 will not apply, giving a notice under 106 of is of no use.
Lordship, AIR 1979 SC
That's right.
1745.
That's right. Why did you choose this judgment?
Lordship,
And what is the law laid down?
Lordship, in this, under the notification, I just saw that the notification talks about their personal occupation, one of the grounds. So in this thing, Lordship has held that the personal occupation does not only mean the personal occupation of the landlord himself per se, but also includes the occupation or bona fide.
This is the judgment which has been rendered first in point of time as far as personal occupation is concerned, to include dependents. I know just followed the law, which has already been laid down.
Yes, Lordship.
I am quite aware that the High Court in multiple times, much before me, getting into the judiciary, had already opined that personal occupation means the occupation of the dependents as well. I was just following the law. Now, there's nothing I have laid down in that. I was quite curious as to why he chose this as the pivotal opinion given by the High Court. But anyway, near this. So, were you pointing out something?
That was my judgment, and Lordship was saying whether this particular point of law was the first, or was it followed earlier? I think there was another judgment of Sikkim
That's right.
which have been quoted there.
Yeah.
And then
In fact, there are I think 2 or 3 opinions of the High Court much prior to that, which had already laid down. So it became so much easier for me to just say what has been said by the High Court earlier, and that's what we need to follow. This is something which we need to discuss. Judicial propriety, judicial ethics, and most importantly, to keep the semblance of sanity with regard to judicial pronouncement. If we followed what has already been laid down, then administration of justice across the state would be at a level playing field. Otherwise, Ms. Jyoti, as the person she is, may give an opinion which is very soft. I may give, being a very stern kind of a person, give an opinion which is much more restrictive. And therefore, just imagine, she's sitting in Gangtok giving this opinion, I'm sitting in Namchi giving contrary opinion. Because somewhere we did not follow the law. The law is settled because the law is already there in the statute book, but that has also been interpreted. That is also, the interpretation is also settled. Do we have then any jurisdiction to give a different opinion? We cannot do that, right? And if we followed that, then we would ensure that justice happens equally across the state. But are we doing that is the question. I don't see it happening. Now in certain POCSO cases I see that happening. In many cases I see judges are following Bombay, Rajasthan, various other high courts, but not our own high court. And there are multiple opinions given by this high court in the same issue which keeps on troubling you. So this is something which you need to be a little careful about, because it may then give rise to an indication to the public that, I may get justice in Ms. Jyoti's court, I may not get justice in Ms. Jola's court. Why should there be a situation like this? Things are easy. That's why I wanted to point that out to you. Although I said it, but I'm the first one to say it. It was said multiple times in the. I was just following the law. So that's what you need to do also. As rightly pointed out, the opinion earliest point in time by a coordinate bench is the binding precedent, right? So when you do that research, look for that. That may be able to give you a clearer understanding of how things are supposed to be. Yeah, go to the next one.
Archip, the next case law which I have taken is under Gangtok Rent Control Act. This is a case of Paul Sanghi versus Mahavir Prasad Agarwala. So in this case, the tenant had filed an appeal against the order of the district judge, whereby the eviction has been allowed and the arrears of rent was supposed to be declared to be paid by him. The appellant, that is the owner, the appellant, that is the tenant, came to the Hon'ble High Court saying that the ground for which the eviction was sought for is not proper, because one of the ground was that the area suit premises was needed because from there the stair would go for construction of the 5th floor. The suit property was situated on the 4th floor.
In Paul Sanghi's case?
Yes. And the second was that out of his children, one of his son wanted to start his own independent business in the property, and also that arrears of rent of 3 months was pending. So the Honorable Judge in the High Court he upheld the decision of the Knowledge District Judge with regard to the arrears of rent, because it was clear that there was no rent paid for the 3 months. But with regard to the ground of personal occupation or bona fide occupation, Knowledge Judge held that the child who apparently wanted to start an independent business was never.
Personal occupation or bona fide?
Bona fide use.
Bona fide, what? What is the phrase? And that is available in which one? Paul Sanghvi was
Eviction.
no, eviction under what? Gangtok Rent Control Act. Okay.
So bona fide occupation, Lordship. So it was held that the bona fide occupation aspect could not be proved because the son who apparently wanted to start the business was never called as a witness during the entire trial also, and even during the evidence of this person, the owner himself also, he just said that because his son was not doing anything, he wanted his son to start his own business. So the Hon'ble judge said that there has to be a distinction between need and a want or a requirement for personal occupation, bona fide use also, and that also that
as opposed to a mere desire.
Yes. So the requirement has to be genuine and not just a ground to evict the tenant on a mere simple wish to do something, and also that even if we consider that the 4th floor was required for taking the stairs to construct the 5th floor also, it was not considered as a total overhauling, which is also mentioned in the Gangtok Rent Control Eviction Act also, as thorough overhauling is not required for full premises because only a portion of the premises would be taken for the construction of the stairs also. And also Lordship has held that the Bazaar committee cannot force a person to construct the 5th floor as per the plan, and that if the person do not want to construct the house also beyond the 4th floor which is already existing, they cannot be made, the compulsion cannot be made to the owner. So the point of bona fide use occupation was not proved by the owner. As such, the decree was overruled with regard to bona fide occupation.
So what is the law later in Paul Sanghvi?
In the law that the word requires signifies that mere desire on the part of the landlord is not enough, but there should be an element of need of the landlord, and that the burden being upon him that he genuinely requires that area for his bona fide occupation.
Okay, now stop there. Take a live case, right? A case pending before you. The plaintiff pleads that he requires it for his, what is the language?
Bona fide
Bona
occupation.
fide occupation. Right, he pleads that. How does he prove this case? What are the different ways in which you could say the plaintiff has managed to prove that it is not merely his desire, but there is a genuine need? How?
Firstly, Lordship, maybe that he doesn't have an alternate accommodation, or that his dependents are more in number and that they require their own space and privacy, or that they want to establish their own business upon which they will be sustaining their own livelihoods.
No, if he just makes a statement, he says all these things, will that be good enough?
No, Lordship, that has to be proved because the burden is on the landlord.
This is again what I am really. Plaintiff will come and say all these things. He will then say that in his plaint and he will repeat that in his affidavit, isn't it? Would that stand proved? No.
The burden will be on the landlord itself.
No. Suppose he sees it. I want this, and I need this, and all that. I need it, I want to set up my house there, I want to set up my business there, whatever he wants to say. He said it. And the cross-examination does not completely demolish it. But he does not need any other evidence to support that. Would, in your judgment, would this Paul Sanghvi's opinion be established that there is you have to come to a conclusion that there is a genuine need and not just a desire, right? Would you be satisfied in getting that answer from the evidence led by the plaintiff by just coming as a witness and saying all that? Or are you looking for something else? What, I don't know. He doesn't do it. I'm asking. No, that's right. Let us say he says all whatever you want him to say, he said it. If you want him to say that I'm dancing in the dark, he will say that also.
I think his deposition should be sufficient to come to a prima facie finding that yes, there is a bona fide need. We cannot ask him to produce some license or whether he's starting some business or going to start a business in the future. We will have to believe that prima facie is.
Because a person who is filing the suit has to bring all evidences. If he fails to do so, then the case will not be in his favor. I mean, there is a section in CBC.
What?
He has to do.
Any other opinion?
He is a inheritor of that and his desire itself should be.
But Paul Sanghi says that is not good enough. You can't not follow the law laid down by the High Court. You can't have a contrary opinion, I'm sorry. You have to follow what Paul Sanghi says. That's the law laid down for you. You can't have a different opinion. I'm sorry, you can't do that. So I'm asking you a simple question and answer that. The evidence led by the plaintiff is his own affidavit. He does not have any corroborative evidence of another witness or documentary evidence as contemplated. Now you have to render a judgment on the basis of an affidavit filed by the plaintiff. How are you going to opine? And pray. May I ask, where are you getting this law from? Where is this source of law that he has to bring something else?
Not only document project, even other witnesses' evidence or oral or documentary.
The Evidence Act defines what is evidence. Right? There are two types of evidence. What are those? No. Oral and documentary. Is there a difference between oral evidence and documentary evidence? Of course, in the nature of it. Otherwise, the weight. Is there a difference in the weight of oral and documentary evidence? You go into multiple thoughts. I'm just trying to see how you all gauge an evidence when it comes to the court.
Under the Gangtok Rent Control Act, the plaintiff has to show with some degree of evidence that he wants it for his bona fide use. I think that word bona fide is important.
Correct.
Which is not there in the other notification, which is for his personal occupation. So bona fide could be, it will not be only for his occupation, but for some bona fide occupation. And for that proof bona fide, I think apart from mere assertion, there has to be some degree of evidence.
What? So that is I'm asking you.
Yes.
What is the evidence? What? Give me example. If you are a litigant, and you wanted to prove this, what is the type of evidence that you would be raising?
For
Sorry?
example,
What witness for what?
for example, Lordship, if he is a married man, he has children. His children also requires these premises for their occupation. Now they have.
No, that's a different type of occupation. We are going into now diverse thoughts. No, I'm just putting a simple proposition. The law is what the Eviction Act says. Here is a plaint which has been filed, right, which says that I need it for my bona fide, whatever that language is. Right? The statement is made. Now he has given his evidence on affidavit and he's been cross-examined. In his evidence on affidavit, he reiterates what he says in his plaint, that I need it for my bona fide use and occupation. Now other party has not demolished it. Other party has not demolished it. हाउडेको लयर पायो उतापट्टि होइन अब के गर्ने भएन अब तपाईहरुले जजमेन्ट लेख्नु पर्यो I am asking you, has he been able to prove or not? He has to prove that we know. Why? भन्यो oral evidence and documentary evidence को केही भिन्नता छैन under the Evidence Act. होइन? It should get same weightage. So why are you not accepting what he says in court on oath? That's evidence. The Evidence Act says it is evidence. So why are you making this now distinction? And if you are making this distinction, what is the documentary evidence for bona fide use that you are looking for? Please tell me. Otherwise, he can support it by additional witnesses by saying, yes, whatever he says in his plaint is true. And you will get 10 number of people who will come and say that. किनभने लयरले बनाउँछ लयरले कपी एन्ड पेस्ट गर्छ PW1 ले भन्छ त्यहाँदेखि PW2 ले पनि त्यही भन्छ PW3 ले पनि त्यही भन्छ त्यो त एभिडेन्स त आइहाल्यो क्रस एक्जामिन होइन कि होइन गरिदिन्छ लयरले सिकाएर it is not a fact, it is not a fact, it is not a fact सकिन्छ now you are faced with the same situation. Now how do you proceed in a case of this nature and give your opinion as to whether the plaintiff has been able to prove that the premises is needed for bona fide use and occupation.
Lasik?
Yes.
This eviction suits Lasik is a civil suit. So the degree of now the certainty of belief in the mind of the court, that is preponderance of probability. Whether that particular degree has been met by the plaintiff.
Correct.
In the case has to be seen, but there is a tendency of Lasik making.
But you are giving me a very general thing. I am giving you a specific situation. What is your judgment? What is your judgment in this situation? Has he proved it or not proved it? Let's go by one opinion. No, it will not depend on. I am giving you the facts. I have given you the evidence also. It will not depend on anything else. He has said what he has to say. He's proved it. Okay. What is your opinion? I won't add anything.
Okay. What I would do is,
yes or no, proved it or not?
if he only says bona fide
Judges
requirement,
need to be very thing.
Lordship, if he only says bona fide requirement, only this
He
word,
is not. He is saying everything you has to say. I need it for my use. मेरो एउटा अफिस सानो छ अब मलाई ठुलो अफिस चाहिएको छ त्यो ठुलो अफिस मेरोमा छैन सबै कथा लामो लम्बा चौडा गरेर सबै भन्यो उले तर ओरल उसको एफिडेभिट मात्रै छ.
if he says all of that, I'll give him. But only bona fide requirement
two,
only.
that's it. 2. Your opinion? 3. Yours? Ranjita?
Since I've read the case facts, I would not allow it.
You will not allow
The
it.
use of languages.
You can't change your opinion. Yours?
I said that.
Huh? You'll allow. 4:1. You? Very good. Who are you? You? Let's ask the senior most.
Lordship, if I may.
One second. Are you with us in the conversation?
Lordship, I feel that apart from just the averment made in his petition, he must support it by way of evidence, Lordship, to show that it is a bona fide need and not just a desire.
So that is why I started this question by saying, what is this evidence that we are looking for? Then, what is evidence? What type of evidence are we looking for? For bona fide use in occupation, what is?
He should bring some other person, independent witness or some.
So therefore, you need a supporting evidence. Supporting evidence. What is it called? Supporting
Yes.
evidence. Corroborative evidence.
Yes, Lordship.
What about you? What is your opinion?
I think I would.
That's how a young mind thinks. Huh?
I would go with whatever the learned judge is asking.
The best. Okay. Let's work on this for a little while. The Evidence Act talks about what is proved. Take out the Evidence Act and see what the Evidence Act says, what is proved. At the end of it, if you get answers on your own, that's good. I'm not going to give an opinion. So, if you're, it's just to provoke your thoughts. Not my problem. That problem which Ms. Ranjita was mentioning. Huh? That's right. That's what I'm saying. Yes, she's got proved. Let's hear this. What is proved under the Evidence Act?
Proved, a fact is said to be proved when, after considering the matters before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists.
First question. Have you all given a thought to this word proved when you're giving your opinion? So basically, as I see, there is a whole lot of discretion given to you to form an opinion, isn't it? It is not the quantum of evidence, but the quality of evidence that is convincing you to render your opinion without hesitation. And that's the spirit of a good judgment. You should be able to give your opinion without hesitation. If you have hesitation, somewhere you're wavering, then your judgment may falter. The word proved does not give you any kind of restriction on what kind of evidence would satisfy you. It could be a case in which corroboration is absolutely essential. It could be a situation where it may be impossible to seek corroboration. I'll give another example. I'm filing a plaint in which I say that Ms. Zola, who is my tenant, has not paid me any rent for 4 months. I file a plaint. Okay? I come to the witness box and I say the same thing. What is the evidence you expect me to lead to prove that she has not paid me rent?
How do I place that? I'm making a statement, you have not paid me.
So now, Lordship, it's ownerships on Ms. Jola to show that she had paid the
I'm making
rent.
the statement. Right? What does the law say? What does the Evidence Act say?
No, but he deserves an opportunity to.
I go by strictly by Evidence Act. What is it? One who assesses must prove it, done in two.
If the rent is being paid online or maybe in a bank transaction.
Situation. You create situation to suit you. It doesn't happen that way in cases. I'm giving you a situation that you are like online. I am telling you the situation. I am saying Ms. Jola, who is my tenant, has not paid me rent for 4 months. I said so in my plaint. I come to the witness box and say the same thing. 102.
Lordship, under section 54 of the BSA now, Lordship, the oral evidence ought to be sufficient if you as the presiding officer are satisfied, because you're giving oral direct evidence to the fact which you have pleaded in your petition, Lordship.
See?
If you have no
To
other
that
reasons.
extent, you must give a clap to the new law that is coming. Isn't it? This is fantastic. I'm glad you brought this up. But that's why I am provoking your thoughts. In this situation which I've given you, right, what is the type of opinion that you are seeking from me? That Ms. Jola has not paid me rent. How will I prove the negative? So your opinion will depend on the fact situation. It can't be a standard format opinion. There could be a case you are satisfied with just the oral evidence. It could be a case in which you needed supporting documents to prove. If I had made a statement that Ms. Jola and I had entered into a written contract and I did not find it. Now you will doubt what I stated. It's a different fact situation. So you have to apply the law to the facts of that particular case. Merely because you formed an opinion on a completely different context on an earlier occasion, don't apply it because you know the law. The same word proved applied in that context and the same word proved applied in this context may give rise to different way of looking at the evidence. We need to be mindful of that. Don't standardize your thought process. Be open to thinking. Critical thinking is very, very important. How do I do it?
Absolutely right. There are many situations like this where there cannot be any proof at all. Let's say, for example, a little out of context, but sexual offense, not sexual offense per se, rape, but harassment. The complainant, or if there's a girl, cannot prove it by direct evidence as to what proof will she bring of somebody who has touched her. Because it could have been
inappropriate.
Yes. It could have been in a private space. So in these kind of situations, we cannot, I think, demand, like in this matter,
Correct.
proof or some evidence to corroborate.
So see how beautiful. I believe it. Your belief, and it can't be just a blind belief. I like your face and I believe. I like your height and I believe. No, it can't be. It is from the evidence that is gathered.
That a reasonable man in that particular
That's right.
circumstance.
A prudent man. And what is a prudent man? Not prudent man. What is a prudent man? When we talk about, this is a language which he uses in the law. Yes. Not, elevated soul like all of us here, who knows the law. So I think that is very, very important. When we render justice, you have to be there. You have to be there, asking the right questions, conscious about all these things, and then gauge it. The way you look at it will give you a good judgment. And that happens if you are attentive in court. That happens when you are really concentrating on the matters before you, on the issues before you. If you are, in a state where you are looking at multiple things, your files and your homework which you need to do in another matter, and the signatures you need to sign on various documents while a case is going on in your court, maybe that you are not in the grip of the matter at all. And that again, the same word proved in the Evidence Act will have a very complex meaning. So this is what I wanted to talk to all of you about. Is there anything else that you are, any other judgment which, there are so many judgments. I'm curious to see which you picked.
Lordship, one more judgment by Lordship only.
Just only अन्याय भयो जस्तो छ. Don't go too much. This Pradhan fraternity. What is it? Anyway.
Actually, I have not taken up any case on eviction till now.
Okay.
So, Lordship, this one also is a case of Lordship where three of the cases have been decided together by Lordship. This is a case of Karma Pinchoputria versus Naresh Chubba and others. Lordship, in this case,
where did it render the first opinion? You had read.
so Lordship, in this
I just
case,
followed what she's opining, and nothing much.
Taken the case of, relied upon the case of Apollo Zipper Limited, India Limited, and Ambika Prasad versus Mohammed Alam, in which it was held that in eviction suits, when the issue of title is raised, landlord is not expected to prove his title like what he is required to prove in title suit. And the other one, Ambika Prasad, that a transferee of a landlord's right enters into the shoe of a landlord in respect of the subsisting tenancy, and atonement by the tenant is not required. So this is what was the case in this, and in this case, Lordship has also held that the owner has been able to prove that he is the landlord because the notices had been sent and the rents were being paid by the tenants to the earlier owner despite having receipt of the notice and knowledge of the change of transfer, and despite that, just because the tenants failed to validate the other person's right as a new landlord would not would not change the fact that the transfer is actually the owner of the supremacies. So that was atonement and.
This is a case in which I thought, I don't know, I have none of you report. This is a case I thought was suffered by the tenant on wrong advice. Absolutely wrong advice. He was paying rent. The only requirement under the rent law is, as long as you are a tenant, pay the rent. He was saying money order to a person who was not the landlord. In spite of being told he is now no longer I am not the landlord, he is the landlord. The tenant is saying that I am the landlord. Think of it. And logic plays a very, crucial part in judicial determination, which I am sure all of you understand. The tenant is telling the court that I am the landlord. I am telling the court and I am telling the tenant, look here, I was your landlord, but I am no longer the landlord, I have sold it to this person. The tenant says, no, I don't believe you. I don't believe you, I don't believe this new tenant, new landlord also. For me, you are the landlord. And I continue to get the money orders of the same amount, which could have been given to this person, and that's the end of it. So this is, I think, where as I understand, you have not understood. When I say you, I'm talking about the person who was filing that thing, understood how the law works. A tenant is a tenant. He can't get anything more than that. As long as he is willing to pay and pays the rent, the tenancy continues. If he fails to pay the rent for more than 4 months, he is out. Right? That's a settled law. He can't be the landlord. He cannot change that situation. So when the landlord himself is saying, no, I am not the landlord, somebody else is the landlord, what right does the tenant have to say that no, you are also lying? I just use logic, and the learned judge also used logic. It doesn't make sense. So logic is also part of judicial thinking. That's the takeaway. Nothing else. Nothing great has been rendered in that. Then next.
Lastly, in this judgment, lastly, the new term, the atonement has come. And in this case, lastly, whether eviction court can decide the title.
No, of course not.
Because the tenant is disputing.
So we've said that also.
Yes.
We've said that in that judgment also. That you don't have to go into the extent of examining title. So that was the case that the tenant was trying to make out. The tenant was saying, no, I asked him for the document, but he did not give me the sale deed and all that.
I think the Lordship has also referred to Gangtok Rent Control Act, saying that there is no definition of landlord like it was in the 1946.
That's right, that's right. And I have referred to Tika Khawa's case. In Tika Khawa's, Judicial has already rendered an opinion that you don't need to do that. So much of the work has already been done by my predecessors. I just have to follow the law. It makes things easier for us.
But if these kind of compilations are given like we have got it now, it would be very helpful. And
that is the endeavor.
I speak for myself and on behalf of, I think, my learned colleagues also, that if a compilation on the, because if a compilation on the POCSO Act could be made, the reason is because there are...
That question, ask the first director. No, the first director will give you what happened. Just tell him. Compilation of the POCSO Act. I'm not saying anything.
It was made, not it. Actually,
When? Please tell me.
It was maybe 2017, 18, it was made. Once I joined.
What happened to that?
There were so many corrections. There were so many corrections, and when I left, I handed it over.
That's right. Until now, it is not out.
There were corrections. It was out. There is a compilation.
There is a compilation. Have we circulated
copy
it?
here. No, we have not circulated it.
That's the
Because
thing.
there
We
was
need to
a
circulate it.
correction in it. And while I left, I handed
Yes,
it
now
over.
the two directors are now talking to each other. What
He
happened?
was asking me what is
A compilation of the POCSO judgments. Where is it?
because Lordship, when we left, we just started with that, and there was corrections
No,
in it.
she had a problem because she and nobody else was there. Now you have a whole team. Now I think it should be out. There's a demand for it. Please circulate it. What you need to do is add the Supreme Court judgments also, which are now available in that.
Lordship, after my joining, I impliedly received the record, Lordship, not through the former director, and we compiled it, Lordship, and after reaching to certain stage, Lordship, then again there was proposal to add more Supreme Court judges, in addition to the judgment delivered by Hon'ble High Court, Lordship. So that is in abeyance, Lordship, to get further direction from your Lordship.
Forget the direction, just do it, no?
Lordship.
Academy must do these activities all the time without the direction of the court. For us, you have continuously do it. This process must go on. If needs to be updated, please update it. You have made this compilation, as I see, it doesn't have many of these things. We have been able to add one more notification immediately after this, and this should be the standing instruction. This needs to be updated. And if you have people who have some spare time, then the index in which you have given the it should also contain a brief to give us an idea as to this judgment is, what is the ratio of this judgment? Slight hint on bona fide occupation, on section 4, on paragraph 2, so that we can easily take it out in. But this is not exhaustive. There are many judgments which have not been put here. So we can update this and keep doing this process. It's a constant endeavor which should be done by the Academy to ensure that the honorable judges are fully equipped to face the challenges they meet every day in the courts.
Because this is a good compilation, I am sure. I think we will keep it forward.
Of course, definitely.
No, this we have, but we have to.
But I'm curious. Sorry, I'm just curious. I'm sure you noticed this in the very first notification. Before we close, under powers conferred in para 2 of notification number 1366. What is this?
This notification was we tried to trace out, and even after the suggestion of non-district session just not wished also, but unable to locate anywhere, even in law department.
Have you written an official letter?
No, no, sir.
Please do it.
Yes.
Please issue an official letter asking the law department or the Gazette section, 2 departments, to give us a copy of this notification. Simple as that. Don't say it doesn't exist, it doesn't do that. There's a reference to this notification, it is there. Because this is referred in 2 places. In clause 4 also there is a reference to this notification. But we don't seem to have it. Because it says, if you contravene this notification, you will be liable for prosecution under para 4. What is this punishment? Only para 4 will say it. And para 4 is not available with us. So how do you then administer this? Punishment was, I think, a very important tool at that particular point of time. So even for matters which had civil consequences, you've been whipped, and that's what I think. Huh?
That's what I also know.
There's a lot of these. Even the thing, we had this discussion earlier also, revenue order number 1, right? The consequences is you shall be punished. Then you should go to the criminal court now. Still applying revenue order number 1. Anything else? Huh? Okay. Anything, any issue that needs to be discussed? Any problems that you face in manning these jurisdictions? What?
That is what notification is.
ठीक है, ठीक है ना? The volume, what is it? No, that must be just referring to that notification. But has anybody seen the notification? It has reference to that as well. We are looking for that notification, 1366. If we don't get it through the normal source, then maybe it would be a good idea is to give a public notice requesting the private people to get it from. Yeah, I'm sure he has it. Then,
You see, when similar issue cropped up before Hon'ble High Court of Sikkim, when I was there in industry, and that matter was pending for a long time to look out and trace out and bring. But the law department unable to trace this particular document, where is just a record. And I think thereafter the issue was decided by Hon'ble High Court without referring this. There are two of notifications.
but that doesn't resolve the problem at all.
Last second.
See, it could be with, Mr. Sonam, it could be in Kenzon House, I'm sure.
Lordship, I-
Few places it may be available.
for it.
Yes. It could be there, it could be. The set of notifications I have, my grandfather's collection, I have given it to the High Court. So High Court has updated it. Maybe you can check.
Even Phokchom Lasip, the High Court,
He doesn't have it.
Lasip is the main person to trace out any document. But
Then that means it's not available with me in my library. Then it could be Kenzon House, it could be Mr. Solomon, could be Mr. Desam. So at least, these private sources you can request and follow up. Is that the end? We've solved all the issues.